for prosecuting your objections. So when the trustee delivers the account to the beneficiary informally, it's not filed with the court. You'll have your period to object, and you can elect to just send written objections to the trustee with your proof of delivery, or you can
echo Don's comment, and I would say you should especially read the trust if you wrote it.
That's right.
Okay. The focus today is on the 2010 no contest clause, and specifically what is a protected instrument. And I'm going to proceed with what I call the California two-step. It seems like everything in the statute has two steps. So under the new law, or 2010 law, I can't break that habit, I guess, so bear with me. Contests fall into two categories. There's direct contests, and there are indirect contests. Now, John or Don is probably going to tell me, well, no, wait a minute, trust agreement. And the issue, the way that I frame it is the above statement sufficient to meet the requirements that the First Amendment, remember it's a separate instrument, contains the no contest clause? Well,
the usual generic language, and I know that none of us ever draft boilerplate. It's always custom and thought over with great thought and care. But we do use some clauses over and over and over again. And I think that it behooves us all to look at those clauses, whether it's an instrument we've drafted or an instrument someone else has drafted, to see whether the clauses are simply restating the probate code authority, which is rather generic and therefore ambiguous, or whether there is particular language rationalizing and authorizing the expense of the trustee's expenditure on attorney's fees for particular acts, i.e. defense of the trust. Send out a new engagement letter, you have the lawyer's fiduciary duty to that client in regards to that contract. So you are compelled to tell the client that they have the right to go consult you. They should consult with independent counsel about the consequences of the new fee agreement. That is something that I think we're
Any other questions? Yep.
Don, the beneficiary of a bypass trust, the remainder beneficiary, has a vested interest, but he or she is not entitled to current income. If the objection is made, request for an accounting objection is made is that you're not entitled to income, and you go to court seeking a court order to compel an accounting for the remainder beneficiary of a bypass trust, what is the probability of the court saying account?
Well, I think they would have to account, because the duty extends because the bypass trust is an irrevocable trust. Right. And so the remainder beneficiaries have an interest in that trust, and so they may compel an account because they are a beneficiary within the meaning of Section 17-200 and Section 24.
Okay.
I think there's a case on that.
Yes,
there's a case actually on that, right?
Yes.
Okay, well, thank you very much.
Thank you all.
Thank you.